Okay, this session is the only thing that stands between us and a drink at the end of a long day. So we have 2 papers and 2 discussants. Our first paper is Aziz Haq's.
Do you want me to stand up there?
Yes, because they're recording it. And would you like 5-minute or 2-minute notice?
You can give me both.
Okay.
So thank you very much to Tom and to the other organizers, including Nancy and Quinn, of this fantastic conference. My paper fits within the third of the enumerated themes of the conference. It is more of a think piece. It is rather than a fully developed project. It's also not quantitative, although it rests in part on quantitative work I've done in the past with Tom Tyler on the dynamics of counterterrorism policing. And its overall aim is to articulate a theory of the social production of national security, a theory that I hope will be a launching point for further empirical and normative work on my own part. First, some background. It is banal to observe that counterterrorism policy in Western democracies treats Muslim minorities first and foremost as a security risk. This was the case in the first year of responses by the United States to the 9/11 attacks, which domestically principally relied upon immigration-related authorities to target non-resident aliens from Muslim-majority nations. It remains true in France, where the emergency responses installed by President Hollande over the last few months have almost exclusively focused upon Muslim residents of France. 2 powerful dynamics shape that association. First, broader popular concerns about migration and economic fragility translate into greater support for nativist politicians. Candidates from nativist parties advocate openly for coercive and exclusionary and discriminatory policies. Second, the Islamic State in Iraq and Syria, or ISIS, has developed a sophisticated social media infrastructure that targets for dissemination, or that disseminates propaganda and targets for such dissemination Muslim minority communities in the United States and Europe. ISIS has also allegedly seeded a network of operatives across France, Belgium, Germany, and the United Kingdom, largely comprising members of those same minorities. In France and Belgium, it's predominantly North African. Without discernible irony, the nativists and the jihadists concur on a point: the impossibility of a Muslim minority in a Western liberal democracy. The alternative hypothesis advanced in the paper, and I hope in the larger project, is that Muslim minorities in Western liberal democracies have a necessary, even positive role mitigating the risk of religiously inspired terrorism. These embattled religious minorities are no mere victims, pinioned between the state and its implacable foes. Rather, their collective efforts to build robust communal lives hinder terrorist recruitment efforts, raising the price of successful recruitment and attacks. Western liberal democratic states, therefore, err strategically as well as morally by treating these minorities as objects of intrinsic suspicion to be tolerated at best if they cannot be assimilated. Why is it useful to have a theory of the social production of national security? The idea that the state is exclusively responsible, has a Weberian monopoly on the production of security, has been rejected in the sociological literature, most importantly by Sampson in the form of his theory of collective efficacy. Yet terrorism seems quite distinct from crime, at the micro level at least. It is concentrated in a handful of individuals. It's not geographically diffused, and it takes the form of singular, spectacular incidents which provoke a fear that, at least to people living in in Europe and the United States, seem as if a different order of magnitude from the fear of crime. So it's not immediately obvious why one should examine the social predicates of security as opposed to the state predicates of security. Nevertheless, there's powerful evidence, anecdotal in form, that Muslim minorities do contribute meaningfully to security against terrorism. The principal contribution of the paper is to start to articulate causal mechanisms to support that claim. There are two articulated in the paper, and there's a third that I've developed in prior empirical work. Down the road, what I hope to do is to weave these together into a larger account of the role that Muslim minorities play in respect to counterterrorism policy, paying much more attention than I do in this paper to some of the operational and ethical questions that that raises. But the three mechanisms, the three causal mechanisms that I want to pass out, and which I'll spend the balance of my time talking about, can be labeled ethical anchoring, ideological competition, and epistemic co-production. And I'll delineate each in turn. So consider first the idea of ethical anchoring against violent Islamist recruitment efforts. The families and co-religionists of those who are targeted by ISIS and Al-Qaeda for recruitment establish a set of normative bearings. They create an ethical bulwark against individual decisions to use violence for political ends. Through the everyday labor of moral education, they act, perhaps unwittingly, as a prior restraint upon violence. Correlatively, in those circumstances where moral norms are weakened or dissolved, recruitment efforts are more likely to succeed. One of the conditions arguably related to high ISIS recruitment rates in Europe has been a waning of authority exercised by religious leaders, imams, who in certain but not all ethnic communities have little experience or understanding of the conditions or tensions faced by Muslim minorities in the West, as opposed to the natal countries from which the imams are drawn. The vacuum of normative arrangements, the normative vacuum is perhaps most obviously evident in contexts such as prisons, where particularly in France and in Belgium, recruitment rates to ISIS have been high. In the United States, a disproportionate number of recruits to ISIS who have been indicted by the Department of Justice are converts, bereft of a thick social network, bereft of a thick normative network in which moral norms are promulgated and reinforced. It's arguable that converts are more vulnerable to the normative retooling necessary for recruitment to violent political action. The second vector of security's non-state production takes the form of ideological competition. Recruitment to ISIS and similar groups targets those who, rightly or wrongly, believe themselves sidelined or ignored by a larger society, and who seek to position themselves as in a countercultural position. The fewer such countercultural positions exist, the easier it is for a terrorist group to recruit new members. Muslim minority communities supply a heterogeneous array of non-violent vehicles for political voice. They compete on the home ground of violent Islamist groups, and in so doing raise the cost of groups like ISIS to recruit. Even if beneficial on security grounds, such competition is not socially costless. In all likelihood, some of the most effective forms of competition to violent Islamist groups are those organizations and groups that hold views that are objectionable on, for example, gender grounds or gender justice grounds. Complicating matters yet further, it has been alleged that some of these groups, Hizbiyat Tahrir is the most important in this latter category, act under certain conditions as portals to more violent political action. It is that concern that has led the Conservative government in the United Kingdom to narrow the scope of previously broad cooperation or efforts at cooperation with Muslim community groups. For example, the Metropolitan Police in London used to have a unit called the Muslim Contact Unit that was particularly responsible for reaching out and liaising with Salafist groups in South London, a neighborhood called Brixton. That unit has been shut down as part of a concern about interacting with radical groups, even if they're quietist. The third important vector for social action, and one that I don't outline in the paper, is one that's the most celebrated by law enforcement. It involves the provision of information about family and community members to law enforcement that would otherwise be difficult for agents of the state either to acquire or to understand given its context. Consider, just by way of example, the efforts of the parents of a 30-year-old British gentleman called Jamshid Jahid who wanted to join ISIS. First, they pleaded with their son not to travel to Syria. Then they stole his passport, and then they reported him to the police. This kind of epistemic co-production is observed in many more investigations than is immediately apparent if one reads the newspaper. It often does not come to light. As a general matter, Muslim minorities are often well placed to mitigate the sharp epistemic constraints on the law enforcement arms of the states. There's been some work recently done on the political economy of the provision of expertise on Islam to law enforcement authorities, particularly in the United States. That work suggests that one should not be overly confident in the ability of law enforcement agencies to outsource their epistemic problems to third parties. Some of my previous work pertains to the circumstances under which epistemic co-production occurs. That empirical work examines the choice of law enforcement techniques employed by the British and the New York police, and suggests that certain forms of discriminatory policing and policing that impinges upon certain privacy norms has a predictable and measurable chilling effect on epistemic co-production among Muslim communities in those jurisdictions. So there can be a tension, that is, between the state's effort to cultivate epistemic co-production, one form of social production of security, and the state's efforts to cultivate production in other ways. So the paper doesn't, the position taken in the paper, just to be clear, and my position, is not that these mechanisms are without their problems or without their limitations. Some of them have, as I develop in the paper, internal contradictions, and all, I think, have significant ethical implications. None of them are normatively untroubling. There is, moreover, the puzzling or difficult, to my mind, question of the extent to which the state is well positioned to cultivate social action that has a beneficial effect upon security. It is not obvious to me that current British and American efforts at such cultivation, the PREVENT program in the United Kingdom, the Countering Violent Extremism program in the United States, are effective or could be effective. I hope, though, that further research, both on the mechanisms of the social production of security and their ethical implications, enables us to better understand, or enables me to better understand, the circumstances under which these the state can play a positive role. Understanding such dynamics, I think, is only becoming more important given recent events in Paris, Brussels, and Indiana.
Thanks very much, Aziz. I'll offer some quick comments before we hear from Kian. Aziz's bold and thoughtful paper turns away from a state-centric perspective on law and legal institutions to direct us instead at the potential of community leadership in thwarting, or at the very least, decelerating terrorist recruitment efforts. His project has three prongs. First, he advocates for community-led counterterrorism as one promising way of addressing the elusive pathways of recruiting fighters through social media. Even as he highlights the complexities of class, geography, and ideology that mark Muslim populations in the US, Aziz grapples with the contemporary historical reality that Islamic State has, through the use of its social media, targeted young Muslims in Europe and the US. Second, he addresses the cluster of normative questions about the relationship between minority religious communities and the state. And third, he identifies community-led counterterrorism as an analytic object worthy of greater scholarly attention, distinguishing community-led counterterrorism from community policing. in order to provide an analytic framework for studying community-led counterterrorism, he posits two possible causal mechanisms: ideological competition and ethical anchoring. My comments are by no means an exhaustive analysis of Aziz's paper. Rather, to help launch our broader discussion, I offer some questions. So, community-led counterterrorism. Even as Aziz notes the dangers of co-option or collusion, real or perceived, he argues convincingly that non-state private actors will have important opportunities to spot and prevent terrorism and recruitment. But the two mechanisms he posits as the causal predicates of community-led counterterrorism, ideological competition and ethical anchoring, don't seem to grapple with the social and relational dynamics that he describes as marking the populations susceptible to recruitment, a social and relational dynamic of youth, disenchantment, and a measure of rebellion that includes attraction to counterculture. From the 3 teenage girls in East London to the young Somali American men from Minneapolis and Portland, Oregon, who were 18, 19, and barely 20, a particular demographic appears to present as high risk. If ideological competition, as Aziz describes it, is the provision of substitute forms of social solidarity and vehicles of collective political action, then how likely is it that young people, already suspicious of authority, will be drawn to vehicles of collective political action and forms of social solidarity that are affirmed, directly or indirectly, by the families and communities in which they are embedded? The second mechanism, ethical anchoring, presents a similar challenge. Ethical anchoring is a mechanism through which members of a tight social network reinforce ethical norms against violence. But how do these tight social networks grapple with the rebellion, disaffection, and suspicion of authority and suspicion of social networks that sees teenagers breaking family rules and concealing plans and beliefs from those around them who might obstruct and dissuade them? Aziz is alert to the difficulties tied to the mechanisms he proposes, but he still posits them as pillars of a viable analytic framework. I wonder if this paradox, proposing as causal predicates mechanisms he recognizes as inherently problematic, I wonder if this paradox has to do with a tension informing the paper between abstractions on the one hand and actualities on the other. So on the one hand, the paper maps the material realities and the complexities of community, policing and surveillance, and state-citizen relations in a post-9/11 context, in which a host of negative and marginalizing meanings have been imposed on the identity category Muslim. But on the other hand, Aziz deploys the language and logic of abstraction when he writes things like all things being equal and invokes the paradigms of competition and resources. If, as he notes, non-pecuniary ideological motives drive recruitment, when I encounter reasoning framed in terms of assumption and market logic, the argument loses its resonance for me. I also wonder, are we then looking at a mimicking of the paternalistic state through state-like surveillance functions within communities? Do community leaders bear an obligation to report suspicions back to the coercive arms of the state? Ideologically, does the paper's understandable focus on Muslim communities replicate the lens of the state? In short, the apparent turn away from the state through a focus on community leadership may paradoxically reinscribe the positions and ideologies of Western states in terms of framing counterterrorism. Is there an alternative? In her essay, Human Rights and National Insecurity, Alison Brisk argues for a view of terrorism as, and I quote, an expression of social conflict reflecting comprehensible grievances, albeit not necessarily justifiable. A view that would help dismantle transhistorical demonizing and help support conflict prevention. What if community-led counterterrorism included an effort to narrate and disseminate these comprehensible grievances? would this role of countering dominant narratives and speaking a version of truth to power help prevent the delegitimizing and counterproductive designations of informant or state lackey on community leaders? Would a broader dissemination to audiences worldwide help add desirable dimensions to the ideological competition and ethical anchoring that Aziz identifies as causal predicates of reductions in terrorist radicalization rates? These questions are necessarily speculative, but as Aziz points out in his paper, difficult questions, both positive and normative, warrant serious consideration when so much is at stake. Thank you. And we'll hear next from Kian Murphy, who's traveled all the way from King's College London. Kian, how should I do it? 5 and 2 minutes?
Sure. I'd like to echo Aziz's thanks to WJP and Stanford for having me here. There's a mini heat wave going on in London at the moment, so it's been a great pleasure to come to California to cool down, see some rain, really get into that holiday mode. I also need to apologize in advance to Aziz, who heard an even more rudimentary version of this paper in London about a month ago, and he will be able to tell you this evening whether I deliver it better when I'm exhausted from organizing a conference in London or when I'm exhausted from jet lag in California. The paper has its origins in an interest in the rule of law, of course, and in terrorism, and in a desire to sort of think through what the organization known variously as ISIS, ISIL, Daesh, or Islamic State means for our understanding of that relationship between the rule of law and terrorism. And it's in some respects tried to point out that terrorism challenges the rule of law. And I would subscribe to what Aziz said about there being, in most cases, some kind of qualitative difference between terrorism and a lot of crime. The guy who steals your bicycle probably isn't trying to overthrow the state, he just wants to steal your bicycle. Now, as the previous panel discussed, once we get into a situation of organized crime and the accumulation of political power by criminal groups, the lines do begin to blur. But there is, as I say, it seems to me a more overt challenge to the rule of law from the terrorist than there is from the ordinary, decent criminal. The other particular point by way of preamble is that ISIS has, of course, achieved what many groups might aspire to but have not been able to achieve, which is effective control of territory from which to launch the attacks that it sometimes sponsors, sometimes merely inspires. And it was this, along with a number of interesting resolutions from the UN Security Council in response, that prompted the desire to take these two things. On the one hand, the organization, and on the other hand, the rule of law, and try to understand the relationship between the two of them. So, to do so, I set out in the paper an account of the rule of law that has 3 dimensions, and I don't claim that there's necessarily any particular exhaustiveness to these 3 dimensions. They simply represent 3 different ways in which I've used the rule of law in my work before, although I do intuitively begin to think that maybe I can coalesce around a sort of a definition or a way of thinking about the rule of law that maybe in future I can find some kind of common normative coherence to. And so the first is this idea of a state of legality. The second is the existence of modal principles of legality. And the third is the inculcation of a culture of legality. And rather than introduce those now, I'll deal with them one by one as I address the challenges to them. Now, in the paper, I talk about challenges that are direct. In this case, this will be the direct challenge to a particular dimension of the rule of law by the non-state actor, by, in this case, Islamic State, or a challenge that might be indirect, insofar as it's a challenge that arises from the international community's response to that threat. I also talk in the paper about challenges as being at either a national level or at an international level. And there I'm just talking about that ordinary distinction between national or domestic law and international law. Now, one of the questions
to which I think we're going to return is the extent to which we can talk about the same things at national and international level. But for reasons I'll get to in a short while, I do think that there is at least some value in talking about the rule of law at international level. So the first challenge that I wanted to speak of was challenged is to the state of legality. And what I mean by the state of legality, for those of you who didn't have the opportunity to read the paper in the 5 seconds it's been available on Dropbox, I think I was by far the last paper in. It's pretty bare. So what I'm looking for a state of legality is that there is government rather than, as we've talked about today, anarchy, and that it is in some way in accordance with or using rules. And so a sort of a rule by law system that we could call a wicked legal system would meet this requirement. It's essentially asking, is a particular territory being governed? And the challenge here from the organization known as Islamic State is pretty obvious. At national level, there has been the effective overthrow of the Syrian State Authority and Iraqi State Authority in particular parts of each's respective territory. I also think there has been the effective overthrow within that same territory of any international state of legality. The most obvious reason for this being that the sovereignty of the 2 states in question has been effectively violated, but also that there have been widespread and persistent, systematic and gross violations of some fundamental principles of public international law, including the prohibitions on ethnic cleansing, the existence of war crimes, and so on. So I think it's pretty easy to say that there's been a challenge to the state of legality in this territory. There are more interesting questions to be asked in this regard. The first is whether we can say there's been a new state of legality formed in this territory under control of Islamic State. And so we can ask whether Islamic State has managed to introduce a new state of legality at national level. Now, one way of trying to answer this question is to ask whether there is in fact a state in this area. And the answer would seem to be for now, no. If we take the Weberian definition of an entity that has a legitimate monopoly on coercive force, we find perhaps a monopoly on coercive force, but questions as to its legitimacy, both internal and external. If we take the classic test for statehood in public international law, which we find in the Montevideo Convention, which is a convention of the Organization of American States, but has by and large been accepted to be indicative of the criteria for statehood in public international law. We find a requirement of a population, of government, of territorial control, and of a capacity to enter into relations with other states. Now, I'm not the first person to run this rule book or yardstick over Islamic State, and there's a bit of difference of opinion, shall we say, in the various attempts at analysis that have gone on thus far. Obviously, information as to what's occurring on the ground in Iraq and Syria is still contested. There's data emerging, but it's contested. And we could, on some readings, come to the conclusion that Islamic State meets these 4 criteria, at least in each of them in part. But many of those who look to the definition of a state now are also reading in some kind of requirement of legitimacy as either an existent or emerging norm of public international law. And so once again, Islamic State falls down on this regard. Now, the failure of a state or the absence of a state does not necessarily mean that my test for a state of legality is not met, because it's more bare. The requirement that there is government and that there are rules. And it's clear that in this area, Islamic State governs, and it does so in accordance with rules, albeit ones which certain agents of Islamic State tend to disregard from time to time. There are examples of violence that is not in accordance with the rules. So we could come to the conclusion that it has within this area replaced the existing state of legality that would pertain to the Syrian and Iraqi states with a new state of legality. At international level, I think it's more tricky. There is a clear intention to rewrite the international rules. The example I give in the paper pertains to a video which is available online. I haven't unfortunately managed to find it myself, but there's a report, I think, in Foreign Affairs of its content, which shows an Islamic State fighter celebrating as a bulldozer bulldozes a large bank of earth, which exists on the line between Iraq and Syria, and the Islamic State fighter is saying the Sykes-Picot line is dead. This was the line drawn by British and French diplomats and soldiers to divide the 2 territories. So there is some kind of intention to reform at a inter- or transnational level the geography, both legal and, in this case, physical, but whether this results in a new international state of legality, I think, will remain to be seen. Second question, and perhaps in doctrinal legal terms the most interesting one in the paper, is whether the response of the international community has been contrary to the international state of legality. And here, without going into all of the details of public international law, it is safe to say that the interventions by members of the international community, in Syria in particular, rests on somewhat dubious legal basis. Russia and, I think, Iran have managed to intervene with the consent of the Syrian government, and therefore their interventions are on a pretty sound basis as a matter of public international law. The other forces there are largely operating out of either an individual or a collective sense of self-defense, the collectivity being with the Iraqi state, which is, of course, also under attack. However, the invocation of this basis, or of this principle as a basis for intervention, is made problematic by the fact that Islamic State is not recognized as a state actor, and the invocation of self-defense and collective self-defense against a non-state actor remains problematic under public international law. There is a UN Security Council resolution on this, but it appears to add little other than perhaps muddying the waters, and I can speak more about that in questions if that would be desirable. The second set of challenges of which I wanted to speak related to modal principles of legality, and here again I've largely taken the work of Raz and Fuller, both of whom I think do roughly the same thing, although I see frowns. I know that they're often seen as in contradiction to each other, but I think both are essentially prescribing certain principles that dictate the form that law should take. Now, we could ask whether these are applicable at international level, and I think that's a discussion worth having. But if we assume for a minute that they are, I can give two examples of their violation. The first relates to provisions in certain Chapter 7 UN Security Council resolutions, which require all states to adopt criminal offences, basically, criminal law and criminal offences and penalties for commission of those offences, for a broad range of things. Classically, many of you will know 1373 in relation to the financing of terrorism, but more recently 2178, UN Security Council Resolution 2178, which requires the criminalization of travel for terrorism. The particular problem from the point of view of the requirement that law be clear and understandable is that it doesn't define terrorism for this specific purpose, opening up a pretty well-known Pandora's box at this point. The second reasonably well-known example of a violation of modal principles of legality is the system of targeted sanctions that the UN has operated, in fact, before September 11th, but ramped up after those attacks, and has reinvigorated in light of the threat from Islamic State with Resolution 2253. Here, under this system, an individual can be subject to seemingly indefinite travel restrictions and asset freezes on grounds of their suspicion of association with Islamic State as well as other groups. There is still not a full judicial review of this system at international level, and many of you will know that this caused the system problems as regards the European Union. So, to briefly comment on whether we can expect the same international rule of law as national rule of law, all I'll say about this at this point is that I think that insofar as public international law purports to target individuals, I think in this regard, those individuals are entitled to expect the same level of protection from public international law as they might from national law, which is, it seems to me, a distinct question as to the rule of law, thanks Jyoti, that might be considered to exist between states. And the problem of how you insert those principles of legal certainty, of access to justice, when public international law purports to target individuals, is, I think, one that we are going to have to address in not just the field of terrorism, but a wide range of fields. And anyone familiar with attempts to harmonise criminal law within the EU will be aware of what those challenges can entail. I didn't want to say much to the idea of challenges to a culture of legality because it's underdeveloped in the paper, but to just explain what that is, it is a commitment to the idea that these rule of law principles are only really effective if they have support from the internal legal culture, that is the culture about the law from the people who operate the system, and also I think the external legal culture, that is the commitment of different publics in different jurisdictions to the rule of law as it's understood in those jurisdictions. And I'm happy to say more about my speculative thoughts about how that might be brought into question as a result of both Islamic State and the response to it. So very briefly, by way of conclusion about the fragility of the rule of law, it's probably unsurprising that the conclusion is that Islamic State terrorism does challenge the rule of law in direct and indirect ways. I think it's worth noting that the achievement of Islamic State of territorial control came about in an area where there was already a weak state of legality. Syria was in the midst of a civil war, and Iraq has been fighting to establish civil institutions since the fall of the Hussein regime. But at the same time, the use of that territory as a base for attacks right around the world with a level of ferocity and geographic dispersal that Al-Qaeda never quite managed to achieve itself demonstrates to us that strong states cannot afford to ignore what is happening to weak states. My greater concern is in the way in which public international law may be subject to reshaping. I'm particularly concerned with, the reshaping of public international law to target individuals, whether through targeted sanctions or by means of UN criminal law offences. There is also something to be said for the worries that's arising in relation to Resolution 2249, which is the resolution that pertains to the use of force in Syria and Iraq, which itself seems to blur the line between the authorization of the use of force and the merely giving of political legitimacy to that use. I think it's interesting to note that most of the legal, or many of the legal problems that arise as a result of public international law arise because the target in question, Islamic State, is a non-state actor. And if we were to remove the legitimacy requirement from our state definition and to accept that Islamic State does have, in many respects, the attributes of the state, it would be much easier under public international law to take legal action against it. The final thought by way of conclusion is that this isn't our first time on the merry-go-round. And the UN Secretary General has himself in a report acknowledged that by and large the rise of Islamic State has come about as a result of the political situation in Iraq and the insecurity in Iraq after the Second Gulf War. Now that Second Gulf War was itself of questionable legality. If I was in Europe, I'd say it was horrendously illegal, but I'm in the States, so I'll say it was of questionable legality. And raised serious questions as regards the rule of law in public international law. And I think that if this project has a future, it's in looking at the ways in which these different direct and indirect challenges to the different dimensions may in fact feed into each other. Because someone spoke earlier, fractals. I do think there is a concern as to some kind of spiral in regards to the erosion of legality when it comes to how we're addressing political violence in the 21st century. I'll leave it there. Thank you.
Thank you, Kian. Tom will comment on the paper.
Thank you very much, Kian. So I think it's a valuable intervention and reminds us that responses to terrorism often do put the rule of law in jeopardy, see Guantanamo, etc. I'm going to start with a very micro comment about your UN Security Council resolutions and then make a couple more macro comments. Kian talks about two different resolutions, the 1373, which is all about the financing of terrorism, very well known. Any individual can be named and basically has no recourse. And that seems to fit your paradigm. I didn't find that your other example very convincing. So Resolution 2178 allows states or requires states to prevent people from becoming foreign terrorist fighters. And you're concerned because they don't define terrorism in that context. But as we all know from the broader international law of terrorism, there is no, of course, single definition. It's contained in all these 13 other treaties, which of course you're well aware of. And it doesn't seem to be very complicated to say that we would just take those definitions, terrorist acts, and easily import it into 2178. So I didn't find that very concerning. So I guess I want to make a comment about your conceptualization. He has three dimensions of the rule of law. State of legality, that just means a government of some kind. Then criteria, the Lon Fuller or RAS criteria, and then a culture of legality. Now I'm always in favor of conceptual parsimony, that is to have the concepts be as sort of narrowly drawn as possible. I'm not sure you need to have culture. That is, if you actually meet, let's just take the Lon Fuller criteria, and you meet the criteria of having the law enforced as, as written and such, and embedded in the actual institutions, you're always going to have something like a culture of legality, at least among state actors. And that's probably good enough. So I don't know that you need to add that cultural dimension. As you say, it's a little underdeveloped in the paper. Now, of course, the main thrust of the paper is to sort of look at rule of law with regard to ISIS and rule of law with regard to the international system. And I have to say, I don't think the analogy the analogy really works. That is, what we think of as the rule of law, the paradigm of the rule of law is really at a domestic level. It's designed to control a state. And of course, the international system lacks such a state. And so to the extent we have an international rule of law, it's probably designed to facilitate the creation of states and the autonomy of those states from intervention from other states, more powerful states, the facilitation of sovereignty. That's what international law, at least, is about. The international rule of law, as you talk about it, has to do with the very small bit of international law which actually allows for coercive action, and that's the Security Council acting under Chapter 7. Yeah, it's a problem. But it's not a huge major. I don't consider it, let's say, to be of the same level as the domestic rule of law, on which I'm inclined to accept E.P. Thompson's view that it was an unqualified human good. I'd maybe take a more utilitarian analysis of the international rule of law. That is, that the Chapter 7 system is so small, in fact, doesn't really extend very far. The final point I want to make is about ISIS and the domestic rule of law. I think if you apply the Montevideo criteria, it pretty clearly is a state, right? It controls territory. It has the capacity to enter into foreign relations. It just doesn't want to, right? So that raises interesting questions about an actor that, in fact, is acting on the international plane but just doesn't admit it. In other words, should we think of statehood as being subjective or objective? And I think it raises interesting questions. I'm not sure I quite understand why you say that if we recognize it as a state, it would be easier to deal with. Because obviously its territory is still contested. Syria would claim that we still need permission in order to go in there. But those are just some fairly minor comments, and I look forward to your reactions.
Thank you, Tom. We're open for questions. Sally and then Frederica, please.
This gets to the sort of debate between Tom and Ian about about are these states and what are the criteria? And the thing Tom just ended with, the idea of controlling territory, that allows you to say that any rebel group that holds territory is a state, and I don't think you want to do that. I think that just doesn't seem right to me. And so I think, and moreover, I think the issue of the rule of law at the international level, whether small or large, still raises exactly the same questions as law on the domestic side. And so I think that, in that sense, I think he's right to focus on that. And of course, with the caveat that you mentioned, that this is not a particularly large amount of international affairs.
Frederica, please.
The question is for Aziz. I wonder to what extent the three mechanisms that you focus on are related to, in competition with, undermined by larger processes of integration or lack thereof. And the question leads to a kind of, I was puzzled that you ended with the role of the state, and I wonder what is the role of those other epistemic, ideological, and ethical communities that live side by side, Muslim communities in Europe, in America, in these processes of community-based counterterrorism.
We'll hear from Bob, and then we'll go to the panel.
Focusing on the Montevideo criteria, and particularly the capacity to engage in foreign relations, that takes two. In other words, other countries that are willing to also agree to enter into such relations, and I'm not sure that's true in the situation of ISIS.
Aziz first, and then.
I think this is a terrific question, and I think it's very difficult to answer. I think the conventional account is that the state establishes conditions of cultural and socioeconomic assimilation and integration, and the failure of such integration is causally related to the frequency of recruitment to terrorism. And so on that account, the state has a role in cultivating certain kinds of integration in order to minimize the risk of radicalization. The problem with that account is that the empirical studies of radicalization do not show a clear relationship between absolute deprivation and radicalization. They don't show. There's no. The best study on that point is one by Alan Kruger that's now, I think, at least a decade old. I think the more persuasive accounts of the circumstances of radicalization, first of all, point to the difficulty of prediction, the fact that radicalization seems to occur to a very small number of people, and predicting which among a large population take that path is extremely difficult, right? You're selecting a very small n from a very large n, and to the extent that one can discern patterns, it is patterns that don't lend themselves to any kind of obvious state intervention. So, for example, there's recent work by Gambetta on the disproportionate representation of engineering and science graduates among those who turn to terrorism, right? So what's the state supposed to do? Stop Muslims from becoming scientists? Make them read Middlemarch? I don't know. Those don't seem... those don't... I have colleagues who would say that is the right pathway. So absolute deprivation is not a guide. Relative deprivation seems to have some role to play, although it's very hard to predict when it has a role to play. The interesting example there is Belgium, where the rates of radicalization and the rates of passage to Syria among the Moroccan and Turkish immigrant communities have been very, very different. So the rate of the per capita rate of young Moroccan men and women traveling to Syria to join ISIS has been among Moroccan Belgians has been much higher than the rate of young Turkish men and women traveling to Syria, and the explanations for that go to the kind of social structures that are available in the Turkish Moroccan community, Turkish Belgian community, sorry, but not in the Turkish Moroccan community. I think you can tell the same story among British Pakistanis and Bengalis. Perhaps the state has a role in cultivating or enabling certain kinds of social structures to persist, but and that might go to, or that might inform the kind of integration or assimilation strategies they take. But I am extremely reluctant to draw some sort of mechanical causal pathway between terrorist violence and the form of assimilation policy. My own view, and it's not one that's defended, or I think I can defend it on the paper, is that economic and social integration, which implicates the other question you raised, which is the attitudes of third parties to minorities, is a moral good in and of itself. Unraveling the barriers to economic entry that Clara Dieter and David Layton and their colleagues have identified, on the one hand, I think is a moral obligation. Eliminating or redressing private discrimination, which in both Europe and the United States is endemic with respect to Muslims, is, I think, a good in itself, even if it does not reduce the rate of terrorism by an iota.
Can I go next, since Barry's question is really to me? That's okay, Kian? Yeah, I don't want to get too hung up on the Montevideo criteria. I maybe spoke too firmly about it. What Bob reminds us of is that there really is a debate in international law of whether their recognition is constitutive of statehood or declarative of statehood. As is it an objective fact and then state recognition just sort of says what already exists, or is it actually constitutive, which is what Bob's point is. You need someone to recognize you to actually count as a state on the international plane. I guess what I really was trying to get at is that, by any objective definition, they have a government, they have probably a lot of the fuller criteria. It just happens to be evil law. People know what law they're going to be subject to, it's clear. And I think it's useful to think about rebel groups with this in mind and not get too hung up on really statehood in some sense. We want to be able to compare them along the fuller dimension, say this one's more like it and this one is more not. And in fact, that actually leads me to believe that your conceptualization could be even more parsimonious by just getting rid of the state of legality criteria. And let's just go back to Lon Fuller or Raz. That's good enough. You got something that sort of says it's a government, it acts like a government, good enough. I know he's not.
Kian.
Yeah, so to take it by issue, on the question of the definition of terrorism, it's not that we don't have in international law, it's my concern with the failure to write one into this particular resolution is that it empowers states to take action against someone that they claim is traveling for the purpose of terrorism, which is pretty far, if we think about the nexus between an actual criminal act and when you're intervening, this is pretty far back from an actual act of violence. And so the idea that there's been no boundaries put on that power and that it's been left to states to determine is concerning to me. It's not that it's not determinable, it's just that the resolution does nothing to determine it.
Just to intervene, but that's true of every resolution involving any command to states to do anything. It always empowers the state to do something and there's no recourse.
But not always
That's the
against
nature of the international
individuals,
system.
and oftentimes with even 1373 has a definition of terrorism for the purpose of the financing of terrorism. 2178 doesn't. So the resolution that we thought was the most egregious from the point of rule of law for individuals conceivable has been trumped, I think, but you're not going to agree, which is fine. On the conceptual parsimony, so I don't want to drag you into too much UK law, but this idea of the culture of legality came about for me because there are certain instances where the UK government has proven very good at designing what seems to me to be an egregious tool of state power to fit into the space that human rights law allows. So terrorism prevention and investigation measures are essentially an evolution of internment. We had internment, then that was found unlawful. Terrorism prevention investigation measures, previously known as control orders, amount to house arrest. But they seem to be lawful under European human rights law in accordance with 3 judgments of the European Court of Human Rights in relation to come back to an earlier point, organised crime in Italy. And that seems to me to be nonetheless contrary to something that the rule of law is trying to get at. And that's why I think I need the thicker conception. I developed it actually in relation to another example, which is the use of special advocates, known on this side of the Atlantic as cleared counsel. Again, something which appears to comply with human rights law while losing all of the things that we're trying to protect with principles of natural justice. So that's where that came from, but in trying to move it into this example, I haven't yet developed that as we agree. And maybe I won't, and maybe I'll cut that back. There's no way I'm getting rid of the state of legality, Tom.
Okay.
Just let that go. Look, the public international law point. So I cut my teeth on British public law and European Union public law, and essentially have had to deal with public international law because it increasingly intervenes in the area of terrorism. So whenever I get into general questions of public international law, I get a little bit uncomfortable, not least because it seems to me to be one of the most technical, positivist areas of law imaginable, but the rules almost never apply anyway, which is utterly frustrating and, contrary to the rule of law as far as I'm concerned. Just on the few points that are made about the Montevideo Accords, the Montevideo Convention and the criteria, I don't think any rebel group would necessarily merit it because they would fail on the government. The government requirement is actually a little bit more complex than just control. You need to have revenue raising, a system for issuing rules, and so on. This is like the Oscars where you're being played off. Just on the willingness to engage with other states, I think this can go different ways.
You just have to match the beams, that's all.
I am not wrapping my response to the question. So there are statements from people on behalf of Islamic State who claim they do want to relate to other states. So actually the willingness on their side might be there. The problem is that's hard to take seriously when your purpose is a global caliphate, which presumably would mean wiping out all the other international states. I think the bigger challenge is whether any other states are willing to engage with it, although I wouldn't be surprised if things settle down and they have control of oil is a resource, and I think someone will ultimately be willing to buy it from them. It is interesting in that they've been described as the most, I think, an unprecedented threat to international peace and security, and certainly there's been a huge groundswell of support for action against Islamic State, but 5-10 years down the line, if they've still managed to hold control, which it's looking like they won't, I wouldn't be surprised if someone's buying oil from them.
I want to apologize. We've been trying to keep a lid on terrorism.
Hamid, did I see your hand up just now? Were you going to ask a question? Bill, please.
If I may, on the question of the rule of law as culture, I'm paraphrasing your thought, maybe misunderstanding Tom's reaction to it. Arthur Chaskelson, who was the first Chief Justice of the Constitutional Court of South Africa under its 92-94 Constitution, was sort of famous in rule of law rules for saying the real test of whether you have rule of law in your country is whether you have a homegrown culture of the rule of law, which measures up against universal principles. And I found that to be profound. And as we sort of traipse around the world looking at whether countries are adhering to the rule of law, again, defined in terms of universal principles, I think that I, at least, and perhaps others on the project, find ourselves asking, is this a homegrown culture of the rule of law? Is it so embedded? Is it so clear? Are its merits so obvious to the citizenry in this country, the members of this community, that they have embraced it and adopted it? Administrations come and go. And my view is that if you care about the stability and durability of the rule of law, it's not a written concept that people run to if they write a constitution. It's more vague than that. I think it's really part of the culture, again, a homegrown culture, a way that matches up with that particular community's culture and religion and economic system. I think that is very much the key to a rule of law that's effective.
Thank you. We'll hear from Eric, Brad, Gillian, and then we'll go back to the panel.
So just following on Bill's comment, I tend to agree with Tom on conceptual parsimony, but actually there's a lot of literature about legal culture. You know, law and society, people have been pondering this for a long time, and I think it goes to the crux of what Frank puzzles about on developing this internalized set of norms that come from a lot of different directions that aren't so easily measured apart from a case study. So I tend to agree with Bill about the importance of a legal culture, because that seems to be at the root of things, maybe even more so, if I could be anarchical, than Lon Fuller's definition of rule of law.
Thank you. Brad, please.
So I'm curious to go back to your idea about international rule of law, which Tom raised. Was he had some problems analogizing, and I was thinking about that too, because if we think about the international system, as we think about it, it's anarchic. And when we think about the rule of law, I mean, the part of it that's most important to me is that it constrains state actors, right? It tells them what they can't do and makes them follow the rules. So who is the international rule of law constraining? It's not constraining the state actors, or is it? And if so, who is enforcing it? So I don't think you can as easily analogize the international system to the domestic system. And if you want to try to develop that, I think it needs to be richer, because I think as it is, as presented, I kind of in favor, could.
Didn't you see it in footnote 59, Brad?
Yeah. Then to follow up, my question would be, how would you measure it? Because if you think about that as sort of a requirement for thinking about these good concepts we want to use, how do we go about measuring the international rule of law? And can it vary across different parts of the world? So this is not international.
Thank you, Brad. Will Gillian, please.
So one of the questions that Barry and I have been trying to figure out more recently has been induce, incentivize ordinary people to cooperate and participate in supporting the whatever your central agency is. And you think of that in our model as enforcement, but you can also think of it as simply cooperating with the centralized enforcement agency. And we started to wonder, well, so if you actually have control, if you have overweening force, so that people are playing along, but they're playing along out of the threat of violence, is that legality? So you might have some of those fuller characteristics, but trying to think through. But if it's working because people are participating, cooperating out of the fear of violence, which I think goes back to the previous panel as well. Is that legality?
Thank you, Gillian. And I'm going to jump in to build on this thread of the discussion I'm remembering Stephen Humphrey's book, Theatre of the Rule of Law, where he opens by distinguishing the concept rule of law from rules or mere law. And of course, it's because rule of law holds within its cluster of meanings a call to justice and legitimizing meanings that we tend to associate with statehood, right? And this goes to the points that so many of you have made. And it relates to the idea of legal culture or cultures of legality, because if culture is about webs of significance, right, the meaning making that ties society together, then some sort of visceral understanding of what is legitimate and what is justice is what will prevent the compounding of violence and coercive force in really illegitimate ways. But over to the panel.
Well, Bill and Eric agreed with me, so I'd say thank you for that. I've nothing further to add on that. With regard to the international rule of law, Brad, and this comes back to something that Tom said as well earlier, because you mentioned sovereignty, Tom. It was interesting. I almost wrote in and then decided that there were enough broad claims with insufficient substantiation without adding this in as well. But I almost wrote in that from the point of view of states, maybe if the rule of law at international level most protects is sovereignty, which is analogous to autonomy for the individual. And then I left it out, but that's where my hunch is. Brad, you're wondering who does it constrain? I think, so from the point of view of states, it constrains what other states can do to them. From the point of view of individuals, which is actually where my heart lies anyway, more so than the states restraining other states, it restrains their own states and other states as to what can be done to them. And the rule of law, insofar as we consider it part of the institutions of governance, is always reliant on other institutions of governance to support it. So when we call on a state to comply with the rule of law, we're asking some institution of the state to check some other institution of the state to protect the individual. So I think the fact that there isn't, a world government doesn't pose a problem in that regard. I agree that the conceptualization needs to be richer, but I think I'm going to still be on the same side once I've made it more rich. As to your question, who would measure it? I know this is a dangerous thing to say in this company, but I'm not so convinced by the whole measuring thing yet. And
Now the music really will start.
yeah, but I don't see how, if we can do this wonderful work as regards to a state, something analogous cannot be developed for the international community. I just don't think, everything you said is a criticism of measuring in general. I don't see how it changes that it's at international level. But that's what I would say on that. And Gillian, yes, control is a state of legality, even if I might not like it, but wicked legal systems are legal systems to me. Unless you have such a thick conception of the rule of law that injects some kind of morality, which Fuller and Raz also, although he's not so keen on saying it, begin to bring you into that domain. But I think that if you've got people obeying rules out of fear of what will happen to them, that can be and is a state of legality.
Can I
disagree.
Yeah. So it's related actually to what I want to say about culture. So of course I know there is something called legal culture. It's generally one of the challenges to it is a social science concept. It's very difficult to observe. So my only point is if we observe conformity with the Fuller criteria, that's only likely to be seen if there is a culture. So that when you're talking about measurement, you don't need to add it as a concept. That's all I was saying. It's not that legal culture isn't important. Now, I thought Gillian's question was very interesting, that that maybe is a challenge to the position I just laid out. You could observe conformity with the Fuller criteria, but out of fear, and I think that's problematic. So now we're getting into that you need some thicker notion of the rule of law. Maybe it's another criteria that the law has to conform with background norms.